Good afternoon, everyone. Welcome to the 6th annual Live from L, featuring lawyers from the Office of the Legal Advisor, U.S. Department of State, who are going to speak today on an international legal issue of grave importance, the Iran nuclear deal. I'm Susan Carmani, the Associate Dean for International and Comparative Legal Studies and Burnett Family Professorial Lecturer here at the George Washington University Law School. It is a great honor for us to be able to host the Live from L program with the State Department lawyers. The George Washington University Law School is celebrating its 150th anniversary. Our relationship with the State Department is of great significance. Secretary of State John Foster Dulles is one of our graduates. His grandfather, also Secretary of State John Watson Foster, taught politics and diplomacy at the George Washington University Law School. We have a number of graduates who are working in the legal advisor's office. We also have faculty here who worked in the legal advisor's office, including Mike Matheson, Sean Murphy, who's here today and is also on the UN International Law Commission, Ed Swain, and John Crook. My colleague Laura Dickinson has worked in the State Department. David DeBartolo, who is with us today, and Todd Buchwald from the Legal Advisor's Office, are adjunct faculty members here at our law school. This event could not have happened without the support of the lawyers from the Legal Advisor's Office, whom I will introduce shortly, and also from the support of Paige Chabora at the Legal Advisor's Office. We are also very grateful to be able to co-host this event with the American Bar Association section on international law. And Sophie Wilmot and Renee Doplick have been instrumental in making this happen. And we are very pleased to have, as another co-sponsor, the American Society of International Law. We're grateful to Mark Agrost and Wes Riss for their assistance. There's one other person in terms of the principal organizers, and he's been with this program from day one, and that's Ron Bettauer, formerly of the Legal Advisor's Office, active in the American Bar Association, the American Society of International Law, as well as a visiting scholar at the George Washington University Law School. Ron, without your help and guidance and vision, this would not have been possible. So let's first give a round of applause to all the supporters of this event today. This year as well, we have new technology, so we hope the quality of the audio and the video is going to be clear. And we also have additional bandwidth. For those of you who are outside of Washington, D.C., we hope the technology will allow you to be able to participate without any glitches. I'd like to thank in particular Cyprian Bolding and his staff, along with our media staff, Liz Field, Andrew Lawrence, Mike Briggs, for making this assistance available to us, as well as to my aide, Selena Davis, who's been here from day one working on this project. Last year, the United States, Iran, and certain major powers reached an agreement that limits Iran's development of nuclear weapons. Lawyers from the Legal Advisor's Office have been instrumental in numerous aspects of the agreement. Today, we are going to hear from those lawyers. In particular, we're delighted that the Principal Deputy Legal Advisor, Mary McLeod, can be with us. This is Mary's last week in the Legal Advisor's Office. We have worked closely with Mary on Live from L over the years, as well as the various public international law advisory committee meetings we've hosted here at the law school. She's going to go to the Consumer Finance Protection Bureau to be the general counsel. Mary, I'd like to take this opportunity on behalf of our law school, the students and faculty, as well as the various friends that we have here, to give you a round of applause for all of your support for international law. We also have today lawyers from the Legal Advisor's Office, whom I'm just going to briefly introduce. Mary will have a chance probably to say just a little bit more about them. The Assistant Legal Advisor, Paul Dean, who works in the area non-proliferation and arms control. Attorney Advisor David DeBartolo, who works in United Nations Affairs. Attorney Advisor Kimberly Gahan, who works in non-proliferation and arms control. And Attorney Advisor Shubha Sastry, who works in human rights and refugees. As I mentioned earlier, this event is being broadcast around the world. For those of you who are online, if you want to send a question, then please send it to livefroml2016@gmail.com. Those questions will come to us. I will be getting those questions, and then we hope that you can be part of the conversation we're having here today in Foggy Bottom at the George Washington University Law School. So, Mary, I'm going to turn the floor over to you. And again, thank you so much for all your support for this program and for all the other programs in international law.
Thank you very much, Susan. And welcome, everyone, to the 6th Annual Live from L. And whether you're a regular or a first-timer, thank you very much for joining us here today. I'd like to begin by thanking George Washington Law School, the ABA section on international law, and the American Society of International Law for sponsoring this event. And on a personal note, I'm really grateful to have had the opportunity to participate in this event for the past several years. And as Susan said, tomorrow's my last day at the State Department, and I'll be starting at CFPB on Monday. You may have already heard that Brian Egan was, to our amazement and excitement, confirmed by the Senate last Friday, and he's going to be assuming his duties as legal advisor really soon, probably maybe as soon as next week. And we in the Office of the Legal Advisor, or L, as we affectionately call ourselves, are excited about his arrival, very excited. Al has the privilege and the responsibility of working on the most pressing foreign policy issues of the day. And so it won't come as any surprise to you that the Iran nuclear deal has kept us very busy on a variety of fronts. Unfortunately, Newell Highsmith, one of our deputy legal advisors who had the lead for Al in negotiating the deal, couldn't be here today. But we have a team of dedicated and talented attorneys who are all deeply involved, and they're here to share their expertise and experience with you. I should note that we're going to be speaking in our personal capacities, so the views that we'll be presenting are our own and not necessarily those of the State Department or U.S. government. Before I turn it over to this outstanding team, I'd like to briefly frame the topic of today's discussion in light of its long history. The Iran nuclear deal, or the Joint Comprehensive Plan of Action, referred to as the JCPOA, was the culmination of a long and difficult process that sought to resolve the international community's longstanding concerns about Iran's nuclear program. These concerns date back to at least 2002, when Iran was found to have 2 clandestine nuclear facilities, one for uranium enrichment and one linked to plutonium production. In 2005, the International Atomic Energy Agency, or IAEA, found Iran was in noncompliance with its agreement regarding safeguards on all nuclear material and all peaceful nuclear activities. And shortly thereafter, the UN Security Council passed the first of a series of resolutions imposing sanctions on Iran's nuclear program. At the same time, starting in about 2003, the Europeans led multilateral negotiations with Iran to try to address these issues, but for various reasons, these negotiations never resulted in a lasting deal. Beginning in 2011, the United States and other Western countries adopted more stringent domestic sanctions, which were aimed at cutting Iran off from the global financial system and targeting their oil industry. In March 2013, the United States and Iran held bilateral talks to address the Iran nuclear program, and in November of that year, these talks resulted in the Joint Plan of Action, the JPOA without the C, among the P5, and that's the 5 permanent members of the UN Security Council, the United States, the UK, France, China, and Russia, and the EU, and Iran. Is that right? It's the EU. Yeah. The JPOA was an interim deal. It was designed to freeze Iran's nuclear program and roll it back in certain respects as negotiations proceeded on a longer-term comprehensive solution. And it was originally intended to last only 6 months, but ultimately was extended by the participants several times as the negotiations on the comprehensive deal, the JCPOA, proceeded. In April of last year, 2015, the P5+1 announced understandings on key parameters for the JCPOA, and the JCPOA itself was concluded on July 14th, 2015. Now, as you can imagine, these negotiations were a priority at the highest levels of the State Department and the U.S. government, and Elle was involved integrally in countless ways. We advised on issues related to the complicated web of U.S. and EU sanctions, on multiple UN Security Council resolutions, on Iran's obligations under the Nuclear Non-Proliferation Treaty and agreements with the IAEA, on general drafting of international agreements and not international agreements, on reviewing legislative proposals related to the negotiations, and more. And this team of attorneys will be able to shed some light on all of these aspects of the negotiations. We will do our best here today to answer your questions, but I hope you understand if we can't answer certain questions due to ongoing sensitivities. And with that, I'm going to turn it over to our first speaker, Kimmy Gain. She's an attorney advisor in the Office of Non-Proliferation and Arms Control. And Kimmy, you can kick off the discussion.
Sure. Thanks, Mary. What I thought I would do is start by spending a few minutes outlining the sort of key elements of the JCPOA for those of you who aren't as familiar. And so I hope you'll indulge me, those of you who are more familiar with it. And then I'll speak to a little bit about my particular role in advising on the nuclear issues and in traveling with the delegation in the last 3 months or so before the JCPOA was concluded. So with that, I'll just start. The basic contours of the JCPOA are that it consists of a general text and 5 technical annexes, one on nuclear issues, one on sanctions issues, one on civil nuclear cooperation possibilities, one on the Joint Commission, which is a consultative body of all of the participants to the JCPOA. And then the 5th technical annex is related to sequencing and implementation issues. In addition, during the negotiations, we worked on a draft UN Security Council resolution and a letter from the P5+1 and the EU, which is also sometimes referred to as the E3+3. So there were a lot of documents. In total, they amount to well over 100 pages, and they involve tremendously complex issues of both, related to kind of the nuclear. The nuclear physics elements and nuclear industrial elements, as well as the sanctions elements. The basic premise of the JCPOA, as with the Joint Plan of Action, the interim deal that preceded it, is that Iran would take a series of nuclear steps, as Mary said, to roll back and to constrain its nuclear program in exchange for sanctions relief. So there are 3 structural elements of the JCPOA that I'd like to highlight today. I think these structural elements really speak to the fact that, as you may have heard in the press if you followed any of this, there was a lot of discussion about how this deal is not premised on a trust of Iran because of our difficult and complicated relationship with them. And I think that principle is really evident in these 3 structural elements that I wanted to highlight for you today. The first is that the JCPOA is that Iran didn't receive any sanctions relief under the JCPOA unless and until it took a series of significant nuclear-related steps. So that's sort of a structure of contingent sanctions relief. And the steps that they had to take were steps that would roll back their nuclear program to achieve what was one of the United States' key negotiating priorities, which was making sure that in the event that Iran were to violate this deal and their nuclear non-proliferation treaty obligations, that it would take at a minimum 1 year for Iran to acquire enough nuclear material for a nuclear weapon. So in the worst case scenario, we will have rolled back their program in a manner that we would have 1 year to develop a response to those actions. The steps that Iran had to take in order to achieve that 1-year breakout timeline, which is in contrast to 2 to 3 month breakout timeline, by the way, before the JCPOA went into effect. Those steps were quite lengthy. They consisted of, for example, Iran shipping out 98% of its enriched uranium stockpile, reducing its centrifuges, which were used to enrich uranium, reduce its installed centrifuges by 2/3, to remove the core of a heavy water reactor that could have produced weapons-grade plutonium as it was designed prior to the JCPOA, remove the core of that reactor and fill it with concrete. Iran was required to remove all of its centrifuges and nuclear material from one particular facility of particular concern, which was the Fordo facility. That's a facility that was buried deep underground, so it makes it the most it makes it the least vulnerable, to any type of military action should it come to that. And in addition, Iran was required to put in place all of the additional transparency measures to verify these nuclear commitments. So I'll get to that a little bit more in a minute. I should say that as of January 16th, Iran completed those nuclear steps, and the International Atomic Energy Agency, the international verification body for this deal, issued a report verifying that Iran had verifiably completed all of those steps. So the second element that I would like to highlight, and that dovetails with the last piece that I noted, is that transparency was fundamental to our negotiating objectives. It was essential to policy officials that we would know what Iran was doing. We were working to put in place this series of nuclear commitments, and it was imperative that we had confidence that there would be a mechanism for verifying compliance with each of those commitments. And so a couple of these transparency measures, and this was the element that I advised on, in addition to Newell, of course, and some of the other folks sitting here. But my primary area of expertise is on the nuclear issues, on IAEA and NPT-related issues. And some of the questions that we were asked to speak to were, we knew that we were seeking provisional application of a particular agreement, IAEA agreement by Iran called the Additional Protocol. This provides the IAEA with additional information and access authorities. And so, one of the things that as a lawyer we were called upon to do was to explain to policy officials what would it mean for Iran to implement the additional protocol? What would that translate into on the ground? How would that supplement the IAEA authorities that they have now? And then, in addition, where might we need to have supplemental transparency measures to verify the nuclear commitments to ensure that sort of every commitment had a corresponding verification ability. In addition, the Joint Comprehensive Plan of Action contains a unique access provision, a special access provision regarding undeclared locations, and this is growing out of Iran's long history and sort of some of the concerns that Iran had in the past developed nuclear facilities without declaring them to the IAEA. So what the JCPOA contains is it contains a special provision that essentially ensures that Iran must provide access to any undeclared location that the IAEA requests access to in no more than 24 days if a majority of the JCPOA participants determine that access is necessary. And a refusal would be contrary to the JCPOA and would have consequences. And that's the third element of the structure of the JCPOA that I wanted to highlight for you today, which is something that we refer to as snapback. It was essentially developed in response to the policy desire to ensure a mechanism that there were consequences if Iran didn't follow through on its commitments. And so, as I'm sure Dave and Shubha will speak to a little bit more, the structure of the U.S., EU, and UN sanctions relief all contain the ability for each of the parties that are providing sanctions relief to reinstate those sanctions in the event that Iran is not performing its commitments. I think I'll leave it there for the structure of the JCPOA and just turn briefly to the transparency measures. As I mentioned, we are called upon to advise on Iran's current obligations and then where we might, how we might match up the various nuclear commitments with corresponding verification provisions or authorities, whether pre-existing or whether in the JCPOA themselves, or both. So in principle, this was the sort of my entrance into these issues. But I was asked to travel for meetings on these IAEA access issues primarily shortly before the March Lausanne meetings that Mary mentioned, where the parameters for the Joint Comprehensive Plan of Action were announced. And I wanted to just, for those of you who are law students or who are thinking about a practice in international law, offer some sort of thoughts on being a member of a negotiating delegation. Because I think that that's one of the things that's really valuable about the Live from L presentation. So in all of these contexts, we've all faced this. You're brought in for a particular area of expertise, but particularly here, given the pace of discussions, the number of issues, and the small size of the negotiating delegation, which was really demanded by the sensitivity of the issues, there was a need for another lawyer on a whole range of issues. And so I had to be prepared, and we in L always have to be prepared to help out wherever you can on a range of issues. Sometimes this might mean coordinating and getting feedback from your colleagues with the real substantive expertise back in Washington if you're on the road. And sometimes this might mean, at least developing an elementary baseline understanding of those areas so that you can sort of help issue spot, help steer conversations in the meetings in a way that, sort of does least harm until you can reach out to the actual substantive experts, not all of whom can be there. I would say, secondly, and sort of related to that, you can never be too prepared. This probably goes without saying, but it means knowing the documents in and out, and also trying to anticipate sort of what are the legal issues that might come up, knowing what the policy issues are under discussion. And so we in L often worked on trying to use whatever little bit of time we had in between negotiating sessions to put together papers on things that we thought would probably come up and probably require an answer in a matter of hours, and which required us to do a little bit more digging. I just wanted to give one anecdote of an example of how to sort of anticipate the negotiating environment that was really useful for me as I was learning as a lawyer how to support these policy negotiators. And that was at one stage in the negotiations where a particular provision had been the subject of negotiations between the United States and Iran. And it was in actually quite a good place. But we also were going to go in a couple weeks and have another set of negotiations on this particular provision. So the State Department nuclear expert reached out to L and asked for me and Newell to provide edits in the following way. He said, give me your thoughts on how you would change this if you were unconstrained, your thoughts on how you would change this if you could only revise one sentence, and your thoughts on what you would do if you could only change one word. And we did that, and we then sat down and had a discussion with him about the purpose of the particular edits, what we were trying to achieve, and I think he carried that in with him to the negotiations with a particular focus on issues. But it also helped me to focus on sort of the constraints and the circumstances that he was facing in the negotiations, recognizing that we didn't want to depart too far from text that was, that we were actually on balance quite happy with, but that we might be able to make certain improvements to. And in negotiations, you've always got to weigh this balance of reopening text for to make edits against sort of the possibility that you could reopen it to changes that you don't want to take. And then I will sort of close by saying that just about as useful as your lawyering skills, equally important, if not maybe more, in some of these contexts, is your disposition, and is really sort of how you work with people who are under tremendous pressure, underslept, and constrained to keep things in sort of a sensitive channel. And you yourself are underslept, traveling all the time, and being asked about a range of issues, some of which you might know, some of which you might feel like, oh, that's not really my thing. I don't know. Why are you asking me? But in general, I think I sort of took a lot of guidance from some of my mentors and predecessors in L to learn that you really just have to be a positive, can-do person, recognize that people are sort of not always at their best, and try to keep an even keel. And I think that while disposition is sometimes something that comes naturally to people, it's also something that you can work at, sort of maintaining your calm under stress and maintaining sort of a presentational style that is reassuring and that is and that's constructive for policy negotiators. That's all I have.
Thanks. So just a very quick point of clarification. So I was introduced as being a lawyer for, human rights and refugees, which might have been a little bit confusing. I just recently rotated into that portfolio, but until recently had responsibility for the Iran sanctions portfolio within L. And worked on these issues during the negotiation of the deal. So I'm going to speak a little bit about the sanctions relief that was provided under the JCPOA. I'll sort of start with some of the background context for the ramping up of sanctions. That was an important piece of the context leading into the negotiations. Some sort of aspects of how our sanctions work with respect to Iran, and then talk about the relief a little bit. So I think, as was mentioned at the outset, there was a ramping up of U.S. and EU sanctions, particularly in response to Iran's development of the nuclear program in the sort of 2010 to 2013 timeframe. One particularly important sanction that was developed at that time was imposed through the National Defense Authorization Act for fiscal year 2012, NDAA, which required the imposition of banking sanctions on banks that engaged in significant transactions with the Central Bank of Iran and other sanctioned Iranian banks. So it had sort of a significant impact on the economic activity that that banks could engage in with Iran, or that Iran could engage in. It did provide an exception for countries that significantly reduced their purchases of crude oil from Iran. So at the time that the NDAA went into effect, there were over 20 countries purchasing oil from Iran, and at the time that the interim deal was concluded in November 2013, there were 6 countries purchasing Iranian oil. So that also had an important impact, was an important piece of context leading into the negotiations. And finally, one additional aspect of that sanction was that it allowed countries that were subject to the exception to engage in bilateral trade with Iran, provided that the revenue from that trade was held in restricted accounts overseas.
Other sort of significant sanctions actions that took place in that time frame were an expansion of sanctionable activity targeting investment in Iran's oil and gas sectors in 2010. Additional banking sanctions were imposed in 2010 under another statute. And then finally, at the end of 2012, there was another statute enacted that targeted individuals and entities that engaged in activities with a wide range of sectors of Iran's economy, so their energy sector, their shipping sector, and port operators. And all of these, combined with the EU's efforts to ramp up sanctions in the mid-2000s, created a complex and comprehensive web of sanctions that really limited Iran's ability to access the global economy. And just before getting to the relief, I'm just going to mention a few aspects of how some of these sanctions worked. So first, you can think of the U.S. sanctions with respect to Iran as falling into two distinct categories. One is the prohibitions on U.S. persons from engaging in activity with Iran and with Iranian persons. And the second is what we call secondary sanctions, or sanctions on transactions with Iran involving non-U.S. persons and outside U.S. jurisdiction. And with just a few exceptions, almost all of the relief provided to Iran under the JCPOA relates to these secondary sanctions. So almost all activity by U.S. persons with Iran remains prohibited unless it's been authorized by the Treasury Department. The second sort of aspect of U.S. sanctions that I wanted to highlight is that while some of these sanctions have been imposed, many of the sanctions with respect to Iran are imposed through executive orders and are subject to executive branch discretion. With respect to Iran in particular, a lot of our sanctions were imposed by statute and are mandatory statutory provisions that require the imposition of sanctions against certain individuals and entities that engage in certain activity with respect to Iran. But importantly, particularly in the context of providing relief, many of these statutes also provided the executive branch with authority to waive sanctions for national security reasons. And third, depending on the authority under which sanctions are imposed, there are three different types of sanctions that can be imposed on individuals and entities engaging in sanctionable activity. So one type of sanction is a blocking sanction, which is blocking a sanctioned person's property or interest in property in the United States. Another is banking sanctions, which cuts off correspondent accounts in the United States for non-U.S. banks. And the third is we have a variety of authorities where the statute or the executive order sets out a menu of sanctions that affect the person's ability to engage in activity in the United States, such as obtaining a U.S. export license or obtaining a government contract. And the authority requires the decision maker to choose from that menu of sanctions. The first two categories that I mentioned, the blocking and the banking sanctions, are administered by the Treasury Department in most cases with close coordination with the State Department, whereas the third category is typically administered by the State Department. The relief that was provided as part of the JCPOA and the interim deal that was mentioned, the JPOA, was done through a combination of the waivers of the relevant statutory sanctions and also through actions by the Treasury Department to suspend or terminate sanctions imposed under discretionary authority, so under executive order. The authority to waive statutory sanctions in most cases has been delegated to the Secretary of State. So with respect to providing sanctions relief, one of State L's biggest or primary roles was identifying the possible areas of sanctions relief. So identifying those areas where we had the authority to relieve the sanction, the parameters under which we could provide that relief, and the ways in which the sanctions could be snapped back. So one of the features you heard discussed was the importance of being able to say that if at any time there was noncompliance, the U.S. could snap back sanctions. With respect to waivers, for example, the waivers by their terms are often of a limited duration and have to be renewed, but at the same time they can also be revoked at any time in the discretion of the executive branch if there were a decision that the circumstances warranted revoking the relief. And one of the other primary roles that L played was making sure that the waivers that were drafted to waive sanctions were properly scoped so that they covered the full extent of the commitment that we had made to provide sanctions, but also excluded aspects of the sanction that we wanted to ensure would remain in place. So, for example, ensuring that transactions that were covered by the waiver the waivers did not allow transactions involving persons that are on what we refer to as the specially designated nationals and blocked persons list, the SDN list. This is a list of sanctioned persons that the Treasury Department maintains, and one of the important features of the sanctions relief was that while certain categories of transactions could be undertaken, they could not involve persons that remained on that list or that remained subject to sanctions by the Treasury Department. And of course, throughout all of this, because the Treasury Department does play a big role in administering sanctions, a big part of our role was also coordinating with them very closely, both in terms of the waivers, because with respect to the waivers, in many cases, the authority to impose the sanction comes from the Treasury Department, whereas the authority to waive the sanction comes from the State Department. So we worked very closely with them to make sure that the relief that we were providing was consistent with how they were understanding the sanction, and we also worked very closely with them on their efforts to relieve sanctions under the executive orders. I'll just provide a brief overview of the relief that was provided under the Joint Plan of Action, the interim deal, which the JCPOA built on, just to provide some context. So when the JPOA was concluded, it initially concluded for a limited time period of 6 months, and then it was renewed for short periods after that. And the goal of the sanctions relief in that context was to provide limited, targeted, and reversible relief to create conditions for further negotiations on the comprehensive deal. So the relief in the context of the JPOA was limited to a small number of sectors. So it enabled trade with Iran's petrochemical sector, crude oil, precious metals, autos, and aviation, and allowed for some repatriation of the restricted funds that I had mentioned at the outset. The sanctions relief also had a limited duration, so it coincided with the period of the JPOA that the participants to the JPOA had agreed on. And finally, it made clear that the transactions could not involve persons on the SDN list. This is a feature that also applies in the JCPOA context, but it had sort of a different significance in the Joint Plan of Action because when we got to the JCPOA, there were a number of Iranian individuals and entities that were removed from the SDN list, and so they no longer had that sort of same restriction applied, whereas in the JPOA you still had the same universe of sanctioned persons and transactions with those persons were not sort of within the universe of relief. So it was more restrictive in that sense. In the JCPOA, the relief was broadened to cover a wider range of sectors. And so it included a much broader range of Iran's financial and banking sector. It included transactions with Iran's entire energy and shipping sector and certain industrial metals. So it really covered a broader range of the economic activity that had been under sanctions up until that point. And similar to the JPOA, we effectuated the relief through waivers of statutory sanctions and Treasury issued the President issued an executive order revoking prior executive orders with respect to Iran that were discretionary. And then, as I mentioned, there were a number of individuals and entities that had been sanctioned and included on Treasury's list of sanctioned persons that were removed from that list and no longer subject to that sanction. And then, as I had mentioned, most of the relief that was provided is provided for non-U.S. persons to engage in activity with Iran. But there were 3 areas of relief that affected the U.S. The prohibitions on U.S. persons to engage with Iran. So the JCPOA included relief to enable the export of aircraft, commercial passenger aircraft and parts to Iran. And Treasury did this by issuing a favorable licensing policy indicating that they would issue licenses for those exports under certain parameters, allowing foreign subsidiaries of U.S. corporations to engage in business with Iran, and authorizing the import of carpets and foodstuffs from Iran.
And all of these actions fit within the sort of snapback framework in that, as I mentioned, the waivers could be revoked at any time. An executive order could be put in place at any time if it were determined that sanctions needed to be reimposed. And the individuals or entities that have been removed from from sanctions could face sanctions again if they engage in activity that continues to be sanctionable. So I think I'll stop there. Turn it over to David.
Thanks, Shiba. I'm Dave DiBartolo from the part of the Legal Advisor's Office that works on United Nations issues. So my role was primarily advising on the UN sanctions aspects of the JCPOA. I'll describe some key aspects of UN Security Council Resolution 2231, which was the resolution that endorsed the JCPOA, that terminated the provisions of previous UN sanctions resolutions on Iran, and then imposed new binding restrictions consistent with the deal. I'll focus on three areas that involve particularly interesting legal issues. First, these binding restrictions on key proliferation-sensitive activities. Second, the relationship between the JCPOA Joint Commission and the UN Security Council. And third, the provisions on UN sanctions snapback. So as Mary mentioned earlier, beginning in 2006 and into 2010, the Security Council passed a series of increasingly strong sanctions relating to Iran's nuclear program. These resolutions were an important part of the multilateral sanctions architecture that helped bring Iran to the negotiating table. It was clear that terminating these previous UN sanctions would be inescapable if a deal were to be struck. The Security Council resolutions imposing these sanctions on Iran had clearly connected them to Iran's nuclear program, and the Security Council had expressed its willingness to terminate these measures if its nuclear concerns were addressed. So we were faced with the challenge of terminating these previous UN sanctions at the point, as Kimmy said, when Iran had taken the steps necessary to reach implementation day under the deal, while simultaneously maintaining binding restrictions on transfers of proliferation concern. And we accomplished this in Resolution 2231 by requiring all states to comply with provisions that were set out in a joint statement by the members of the P5+1, which was agreed as part of the deal. And this statement was annexed to the Security Council resolution. So through this innovative approach, the Security Council maintained important binding measures on a range of activities of proliferation concern. These restrictions include prohibitions on the transfer to and from Iran of ballistic missile-related items, prohibitions on exports by Iran of arms and related material, prohibition on the transfer to Iran of certain types of advanced weapons. And the restrictions also include a targeted asset freeze and travel ban on individuals and entities designated for proliferation-sensitive activities, and also restrictions on nuclear-related transfers, in particular that only transfers approved by the Security Council as consistent with the deal are permitted. So the language that the resolution uses for these restrictions is different. It's more positive than the language that was used in the previous sanctions. So whereas the previous sanctions said that the covered activities were prohibited, these restrictions in this resolution in 2231 say that the covered activities are permitted, but only if approved by the Security Council. So while the tone of the language is more positive, the legal effect is the same. The covered activities are prohibited unless approved by the Security Council. These measures remain in effect for a number of years to come, some for 5 years, some for 8 years, some for 10 years, unless before that time the IAEA reaches the broader conclusion that all nuclear material in Iran remains in peaceful activities. Second, let me talk a little bit about the way that the JCPOA and the resolution deal with nuclear-related transfers. So the JCPOA establishes a joint commission composed of the participants in the deal, and within it a procurement working group to, among other things, review and make recommendations on states' proposals for nuclear-related activities with Iran. The Security Council resolution then provides that such recommendations by the Joint Commission are deemed to be approved unless the Council decides otherwise. It's unusual for the Security Council to create a process by which it reviews and by default approves recommendations from another body. While we would normally be concerned about preserving our prerogative under the UN Charter as a permanent Security Council member to veto Security Council decisions approving projects like these, here those concerns were allayed because the Joint Commission's recommendations on these proposed activities must be made by consensus, and we, of course, participate. So we can ensure that any inappropriate proposals are not recommended for approval. Third, with respect to snapback, as has been discussed, this was a provision that was extraordinarily important to us. It's unique. It's unprecedented for a Security Council resolution. The language in the resolution itself is a little bit arcane, but the effect is powerful and simple. If any JCPOA participant state notifies the Security Council of an issue that the state believes constitutes significant non-performance of commitments under the JCPOA, then all of the previous UN Security Council sanctions automatically snap back into force unless the Security Council decides otherwise. And of course, any permanent Security Council member could veto any decision otherwise, any decision not to snap back the measures. So the result is that any JCPOA participant state, such as the United States, can trigger snapback of all of the previous UN sanctions without snapback being subject to a veto. So let me conclude by saying that this provision in particular is, I think, a vivid testament to the persuasiveness and the tenaciousness of our negotiators, including Kimmy, who were able to convince the other permanent Security Council members to create this unprecedented snapback provision that is not subject to a veto. And happy after everyone else has spoken to discuss any aspects of the resolution in greater depth. Thank you.
Hi, my name is Paul Dean. I'm also in the Office of Nonproliferation and Arms Control in L. And mindful of the time, I want to make sure we have enough time to get to questions. I just wanted to say a couple quick words about the non-legal nature of the JCPOA itself, as well as sort of the complicated web of legal and non-legal documents at play in the negotiation more broadly. And then wanted to wrap up just by sort of highlighting what I think you've heard here today, which I think is very revealing about the role of L in complicated international negotiations like this. So on the nature of the document, I think it's relatively well known in legal circles that the JCPOA itself does not impose obligations that are binding as a matter of international law. This is something that we in L spend a great deal of time talking to clients about, offering options both in terms of the implications of going a legally binding versus a non-legally binding route, and also advice on how to make sure that the text itself reflects the intent of the state's parties on the question of whether to be bound or not bound as a matter of international law. So again, the JCPOA not legally binding, which means that it in distinction to a treaty, as the term is used in international law, a legally binding agreement that's governed by a body of international law that speaks to entry into force and interpretation and amendments and remedies. The JCPOA is not governed by that body of law. And I think one thing to really underscore here, which is something we underscore to clients very often, is that this is not a qualitative judgment about the importance, significance, or efficacy of the deal itself. And this is, I think, a critical feature of the JCPOA, that the enforcement mechanism of this deal does not rely on international legal remedies. The enforcement mechanism of the deal relies on the inherent reciprocal, mutually reinforcing set of commitments that the deal enshrines. On our side, and you've heard Shobha talk about the sanctions, we have our sort of side of the deal is the lifting of sanctions. In Iran's side of the deal, just to make it a nutshell and sort of grossly oversimplify, are the nuclear steps that Kimmy's talked about. It's that sort of reciprocal, mutually reinforcing aspect of the deal. If they do that, we will do this, that keeps both sides locked into compliance. And as such, policymakers took the position and the decision that there was no need to take recourse in the international law rules that you would get if you put this deal on an international legal footing and made it a treaty, in the international law sense, again, an international agreement. And I think that sort of is borne out by our experience for decades in solving complicated international problems, especially in the area of national security, nonproliferation, and arms control, through this mechanism of non-legally binding international arrangements. And it goes back to the Helsinki Final Act in the 70s, all the way through a couple years ago, the framework to remove chemical weapons from Syria. These are deals that work, but that are not on an international legal footing. And so it's sort of an odd thing for lawyers to spend so much time talking about non-legal documents, but the reality of it is that we do. And we talk both in terms of the implications of proceeding down the legal route versus the non-legal route, but also, and this is something that Kimmy has spent much of her 3 months overseas in doing, is talking to clients about how to make sure the document accurately reflects that intent not to be bound. And we rely on a consistent drafting practice to make sure that when the United States signs up to a legal agreement, that intent is reflected in the deal, and conversely, when we sign up to a non-legal deal, that lack of intent is reflected in the deal. To make matters even more complicated, in a multilateral negotiation like this, you're dealing with, on our side, states who have subtly different conventions to reflect their intent to be legally bound or not be legally bound. So, as is often the case, there's a mini negotiation at the outset about conventions in the document to make sure that everyone is on the same page, that this document reflects our mutual intent not to be bound on the international plane. So it's an interesting subject, and one that had gathered a great deal of interest, I think, even in the Congress over the spring and the summer of last year. And it's something that we in ELL spend a great deal of time advising on. And I think it's actually a good segue to sort of a sum up, which is that I feel like this deal and this panel discussion of this deal really is ELL in a microcosm in a lot of ways. I mean, you sort of heard from Kimmy about the work on a delegation and the sort of throwing out options, making sure policymakers are armed with options to make sure the deal sticks, advising on the scope of international law. There is international law that's implicated by this in the Iran IAEA legally binding international agreements, the safeguards and the additional protocol, the UNSCRs impose international legal obligations. So advising people on the scope of international law, on the sort of non-binding versus binding aspects. I mean, what Shubha spent a lot of time talking about was the domestic law, which is just incredibly complicated in this area. And as is often the case when ELL works on deals on the international plane, the sort of outer limits of our ability to deal are governed by our domestic law. And we have to know in excruciatingly minute detail what our domestic law ability is to implement whatever commitments we come home with. And so that's another thing that ELL spends a lot of time doing. And obviously, in a deal like this, the UN is such a major feature and a major player that it happens over and over again, where we have a specialized body of lawyers just advising on UN practice and how to navigate the Security Council process, what the precedents are for getting decisions out of the Security Council. And you really sort of see it all tied up here. And I think one thing that I hope you've come away with is sort of the layers upon layers of negotiating that happens in a major negotiation like this. And for those of you who are interested in pursuing careers in international law, I think it's very illustrative of sort of the adage that every bilateral negotiation is a multilateral negotiation, and every multilateral negotiation is like 10 multilateral negotiations. I mean, there are negotiations within the executive branch. There is a negotiation with Congress. There are negotiations on our side of the table. Lots of negotiations on our side of the table. Then there's the actual negotiation with Iran on the other side of the table. and then repeat the whole process in New York. So I think it does give you a real sense of sort of what Elle does, what Elle's role is in the sort of in the State Department and as a member of a negotiating team as well. So again, thank you for your interest, and thank you very much to GW for hosting, and I think we're happy to take questions.
Thank you so much. I'll stay here because I've been getting some of the questions through the email from the audience. And the first question is from Glenn Delakian. We'll have questions from the audience here too, but I think this question plays in nicely to Mr. Dean's observations and the like. But his question concerns interagency cooperation. And I know it'll be difficult to answer in terms of details, but how many departments and bureaus in the U.S. government were involved in working on this deal? And in particular, how would you describe the efficiency of the process and your relationship with your counterparts in the agencies?
Sure. How many were involved? I would say I can't put a number on it, but it was a lot. And certainly, there might be particular areas of focus where one agency or another sort of had more of a substantive role. But I think that the basic answer is that there was tremendous interagency cooperation on these negotiations. That's borne out by some of the hearings that you would have seen if you guys, if you were following the review period for the JCPOA, at which 3 cabinet secretaries testified: Secretary of the Treasury Lew, Secretary of State Kerry, and Secretary of Energy Ernie Moniz. Both Secretary Kerry and Secretary Moniz were in Vienna in the negotiations in the final stretch for a solid 3.5-week period, and for a large chunk of time prior to that. Secretary Lew was obviously also very engaged from Washington, and we had tremendous support throughout the interagency. So I think it was really a testament, actually, to that process, and to how that process can coalesce to achieve U.S. policy objectives.
There's another. Anybody else want to shed light on that? Because there's another question I'll tee up, and it's from Franz Ullman. He's here. Okay, but he's a partner at the Wix Group, but also he writes for The Diplomat, a foreign affairs journal covering Asia Pacific. And he asked, in particular, David, to you, about the role of China in the drafting or negotiating of Security Council Resolution 2231 and the JCPOA. Is it fair to describe the role as constructive or less than constructive from the U.S. perspective? And I think he prefaces the question with observers in the United States taking an interest in China vis-a-vis Iran, and in particular, accusations of protecting Tehran or economic interest in Iran.
Thanks, Susan, and thank you for the question. I think I wouldn't be in a position to characterize the relationship of any particular member of the JCPOA with respect to the drafting of this resolution, but I guess I would say that the resolution was of course adopted unanimously, and it contains, as I said, a number of very innovative and unique provisions, including continued restrictions in a number of areas, including other provisions that facilitate the effective implementation of the deal. And I think that the fact that all of the permanent members of the Security Council, and ultimately all of the members of the Security Council, came together to agree on that resolution, on those provisions, as part of coalescing around this deal, speaks a great deal to the determination of each member of the P5 to pursue this deal and have a Security Council resolution that reflects it. So, thank you.
Just a follow-up question. Do you think the success of your negotiations and China's participation is reflective of the unique structural nature of, as you described, the JCPOA, and the fact that the P5+1 includes China as a permanent member? In a sense, it's very interesting when you describe a sense of a delegation from the Security Council to this lower body of its responsibilities, knowing, in a sense, maybe perhaps the member states were comfortable with that because of the fact that they're represented in that subsidiary body, if you will.
So I do think, as I mentioned, that the fact that each member of the P5 is represented in the Joint Commission as part of the deal provides great comfort to us that we have visibility and involvement and participation and a decision-making role in the Joint Commission's activities. I imagine that the other members of the P5 also feel the same way.
Yes, questions from the audience. Mr. Bettauer. You may want to just come forward since the mic is back there, but we'll use the mic over there.
Folks, something that's piqued my interest has been just at implementation day, there was a major Iran-U.S. claims tribunal settlement releasing a lot of funds. NPR and the Washington Post said those were the frozen assets. Of course, that's not true. They were foreign military sales, trust fund, and interest thereon. But I'm curious about whether you can say anything about whether there was a connection. Secretary Curry apparently said there wasn't, whereas the two in NPR and Washington Post said there was. And it happened just at the same time that assets were supposedly being released to Iran.
Well, I don't think there was a direct connection. But what I do think is that the JCPOA has opened up possibilities of working out issues with Iran in other areas. We'll have to see how it goes. We'll have to see how implementation of the JCPOA goes and so forth and so on. But there are other issues between the two countries. And I think, and actually it just was kind of a coincidence that it all came together on the same day. But, so you can say it's connected or not. I mean, there wasn't a deal about implementation day and this other issue. I can say that.
Great. We have a microphone. Maria? And then after that, we'll have Patrick.
Hello. Does it work? Works? Maybe I can just scream.
For the broadcast. So please introduce yourself. It's on? It's good.
Okay. Sorry. Maria Georgesca from the George Washington University Law School. Thank you so much for the presentation. I thought I knew something about sanctions. Now I'm even more confused. I have a question about Ms. Sastry. So if you would be giving advice to an EU company, a lot of EU companies are rushing now to Iran. Are they still liable for secondary sanctions? Because the nuclear agreement does not cover all sanctions the U.S. has against Iran. And I was wondering if you could give a practical advice to EU companies and if they might be liable in future. And I have another comment, if I may, for Mr. Dean. Would it be fair just to call the deal not internationally binding but still legal? Because it's a legal document. The only thing is that it's not internationally binding. So this is just my comment. It's just confusing for international lawyers to see, because General Assembly resolutions are also not binding, but they're still legal documents. So I just wanted to see if more clarification can be done on that. Thank you.
So my general advice is to hire sanctions counsel. And it would be sort of hard to give general counsel right without sort of a specific situation, but you are absolutely correct that that is not all aspects of U.S. secondary sanctions that have been relieved, and essentially have to look to the terms of the documents that were executed to provide the relief to determine whether it covers the particular activity or transaction that's being contemplated. So that means looking at the waivers, it means looking at Treasury Department's guidance and executive order and frequently asked questions, laying out what the contours of the relief are. Broadly, you can identify things that are definitely outside of the scope of the relief. So, for example, transactions with persons that are still on the SDN list, are still subject to sanctions. There are certain other areas that are still subject to sanctions, but in general, I think it's just a matter of consulting the legal documents that were executed to provide the relief to determine whether it's within the scope.
Can I just piggyback on that about the second point on the legal nature of it? I'm not sure I completely understand what point you were making. If I do understand it correctly, I think I disagree with it, which is that when I talk about, and when in general U.S. lawyers at the State Department talk about legal documents versus non-legal documents, what we're talking about is whether there is in the document the reflected intent of a state to be bound to an obligation that's governed by international law. And so when I say the document is not a legal document, I mean that there is not in the document any obligation on the state governed by international law. That's true of the JCPOA. It is not a legal document because it does not contain any obligations that bind any of the participants to it as a matter of international law. It's also true of an UNGA resolution. That at least any other resolution I know of, there's no legal obligation. The obligation to abide by decisions of the Security Council comes from our treaty commitment under the UN Charter, and states can reflect an intent to be bound on the international plane through any sort of international agreement that they want. But when we talk about something not being a legal document, I'm using it in that sense that there are no obligations governed by international law reflected in this deal.
Thank you. Patrick? And the microphone is working for the audio outside of here, but it doesn't broadcast inside, so just make sure you speak up. But the room is quite small, so everybody in the room should be able to hear you. Thanks.
Well, thank you. My name's Patrick Stewart. I'm a 3L here. So, piggybacking on the first question, connected or not, Iran now has access to billions more dollars, and as long as the sanctions are not snapped back, so to say, they will continue to increase the funds that they have. Because of that, does that cause any concern about the efficacy of snapback sanctions if they ever are snapped back? The sanctions that were in place for years before Iran finally went to the table and committed to a deal.
So it's a policy question I think you're asking about the sort of the policy decisions behind, and we may be the wrong forum for the question, but if there are sort of thoughts on sort of the nature of snapback and our confidence in the sort of snapback mechanism to work, we're happy to say some words. Either of you?
Yeah, I mean, I can say there are sanctions that have been put in place during periods where there was a significant amount of economic activity with Iran, and the U.S. was able to implement strong sanctions in that context as well, despite the fact that there was sort of ongoing economic activity. So I would just say there is some sort of historical context for that type of situation.
We have a question from Robert Torreson at Sidley, who it's a detailed question, and so it requires somebody with some specific knowledge here on an aspect of the JCPOA Annex. In Section 5.1 of Annex 2, the United States committed to here we go. Out comes the annex, right? No, the United States committed to license non-U.S. companies owned or controlled by a U.S. parent to engage in certain activities in Iran consistent with the JCPOA. And on implementation date, the Treasury Department fulfilled this commitment through publication of a general license. While negotiating, was the United States government seeking to achieve through this, or what was the United States government seeking to achieve through this? More specifically, was the objective to attempt to level the playing field between U.S. and European or perhaps other non-U.S. competitors?
Yeah, I think that what I hope that the audience will understand both here and online is that we're not really here to speak about the policy priorities and the policy analysis behind the particular elements of the deal. What we as lawyers do is we're sort of in service to the policy clients, and that's both sort of a blessing and a curse. But I think that we'll have to leave that to we'll have to leave it at that with respect to that question, which I think is really about sort of why did we do this?
Okay, great, thank you. Yeah, we'll get the microphone to you.
Thank you. Shari Brown, Troutman Sanders. With respect to the looming possibility of snapback, I'm curious about whether or not anyone here has any indication that the Europeans who have entered agreements with Iran or Chinese companies that have entered agreements with Iran have contingencies in those agreements that contemplate snapback, and whether or not you're advising U.S. companies whose foreign subsidiaries intend to do business with Iran to have specific contingencies in any agreements because of the threat of snapback, however theoretical that is. Not sure how practically that's actually going to work.
Yeah, unfortunately, to continue the theme, I don't think we can speak to what provisions are in contracts with private, among private parties, certainly we try to be as transparent as possible about what sanctions remain in place, what the scope of the relief is, and have been very clear that snapback is an option that we've worked hard to maintain in case of noncompliance, but the extent to which private parties are taking that into account in their dealings, I think we just can't speak to.
You are recommending it, though, right? That they have a contingency? Otherwise, how can snapback work?
Yeah. Yeah, exactly. So I think that, we're not, I think private parties have to take into account their own sort of risk management and risk compliance practices in light of what the possibilities are for snapback or, what the sanctions landscape is, just as they would have before the deal was reached. I think they're still in the same position of just evaluating what their risk tolerance is and what makes sense as a risk compliance strategy, but not something that the government can dictate to private parties.
We have a question online from Marco Provedera at Provedera Law in New York City. And I think this will probably be for you, David, and since we're on this topic as well. He says, could you please once more clarify the mechanism under which a possible snapback of sanctions wouldn't risk incurring into a veto by one of the Security Council permanent members?
Sure, thank you. Happy to do that. So as I mentioned, under the deal, under the deal, there's a dispute resolution procedure that is discussed. I won't get into that. I'll focus on the Security Council resolution aspect of this. And the Resolution 2231 provides that if a JCPOA participant state notifies the Security Council of an issue that the state believes constitutes significant non-performance of its commitments under the JCPOA, then so the simple answer is then all of the previous UN Security Council sanctions snap back automatically into force unless the Security Council decides otherwise. So in the resolution, it's slightly more detailed, and the procedure is a little bit of a tortuous one. If a JCPOA participant state notifies the Security Council of significant non-performance of commitments, as I mentioned, then a procedure is started by which a Security Council vote is teed up on maintaining the sanctions termination that the Security Council decided on in Resolution 2231. So a vote is teed up on maintaining the termination of the previous sanctions. And if that resolution is not adopted within this time period, then the sanctions snap back under Security Council Resolution 2231. So because the resolution maintaining the previous termination can be vetoed, if it is vetoed, then sanctions snap back. So just to play out a hypothetical scenario, if any permanent member of the Security Council were to determine that there were significant non-performance of commitments under the deal, that permanent member could notify the Security Council of that. A resolution would then be introduced to maintain the termination of the previous Security Council sanctions, and that permanent member could then veto that resolution, with the result that 30 days after the notification was made, all of the previous Security Council sanctions would snap back into place. And there is no way that any other permanent member of the Security Council could prevent that snapback from happening. So that's the kind of a more detailed description of the snapback provision.
Great, thank you. Yes, gentlemen, you had your hand up. Yeah, we'll get the microphone to you.
So pursuing what you just said, Mr. DeBartolo, so if the UN Security Council... Oh, yes, I'm Louis Rothberg with the law firm Morgan Lewis here in Washington, D.C., right? So if the UN Security Council took action to put to allow snapback to occur, would that then thereby trigger a legal obligation under international law for the other member states to reimpose their own national sets of sanctions against Iran?
It would trigger, if snapback were to occur, it would trigger an international legal obligation on all UN member states to implement and carry out the UN sanctions on Iran that were in place before Resolution 2231. It does not address it does not include any obligations on states beyond that with respect to their own national measures.
Hi, my name is Babak. I'm a student of GW. My question is regarding this actually deal somehow has a main feature which is snapbacking the sanctions. So, and by the other side, you have some international investors, not only from EU, I mean, like maybe from China or other countries, that they are eager to invest in Iran. And one of the features of the sanctions that makes it, I can call it shaky for the Iran economic long-term relations is that somehow makes it risky for the investors to come to Iran. I just want to know your evaluation in this regard. I mean, how was the effect of this deal? Is it very positive or negative, or how you can describe this deal regarding to investors who want to come to invest in Iran?
I think if I could just speak to that in a general way, it's that the snapback provision was always intended to be a deterrence for noncompliance. It's an incentive for continued compliance. And the incentive for continued compliance is to ensure that the sanctions relief doesn't go away. And so I think that, as Shubha mentioned, we've tried to sort of explain the premises on which the United States, the EU, and the UN are providing this sanctions relief. The predicate to that is continued performance of the nuclear commitments by Iran. And so I think that we can't speak beyond that to what that means for the pace, the likelihood, or the assurance of investment. As Shubha mentioned, that's for these entities to determine, knowing all of the facts. But certainly, snapback is intended to be an incentive to continued performance and a reassurance on particularly the U.S. side, but on the side of the others who are relieving sanctions, that we would have effective steps to take if there is non-performance.
In a similar vein, there is a question from somebody in the audience who doesn't want his name read. But it is basically the perception that the sanctions are going to keep a lot of U.S. sanctions in place and prohibit U.S. business from entering the market while other companies from around the world, other countries will be able. So the question is how does this benefit the United States with the primary sanctions still in place?
Well, I think the primary, how does it benefit the United States is, I mean, part of the objective of the deal, right, was to address the significant concerns with Iran's nuclear program. And the sanctions relief was, you know, sort of the package of sanctions relief was included in the deal as, you know, a part of the commitments on our side that were necessary to get the important nuclear commitments from Iran. And so I would say from that perspective, the sanctions relief commitments that were made accomplished the objective of getting the changes to Iran's nuclear program that the United States was seeking.
Yeah, I read the question. It was obviously not for me, but I was thinking about the forward-looking nature of this. If investment does come to Iran and there's major economic development, what other changes perhaps there could be from the United States in light of that, if there is this substantial economic growth and there is a sense of security with regard to the situation. So just, yeah. Yes, ma'am. You may want to come forward, just use this microphone here since it's easy to have you speak.
Thank you. I'm Geeta Arya. I'm with the Voice of America, the Persian Service. And I think my question goes to Kimmy. I believe you said you had to explain the NPT, Iran's obligations towards the NPT and how Iran would benefit or not benefit from the NPT for the U.S. delegation. As you recall, Iran used to push back a lot and say that enrichment was an inalienable right of any member country. How was that worked out? And also regarding access to undeclared sites, again, Iran is still kind of saying that military sites would be off limits. So does the deal definitely cover that as well?
To the first point, I think that really goes to the parameters, the kind of policy parameters under which the United States and the P5+1, sort of were willing to engage with Iran. And so I can't say too much about the background of the enrichment, how enrichment is handled under the JCPOA. What I can say is that on the access provision, there's nothing in the JCPOA or in any of the IAEA agreements that would carve out military sites. And so, certainly we've seen public statements, and we would have to cross that bridge if and when we come to it. And that's part of the reason why some of the mechanisms that we've built in, for example, the special access provision providing for the Joint Commission to advise on the necessary means to resolve IAEA concerns regarding access to an undeclared location, and for that issue to be resolved by 5 of 8 members of the Joint Commission, unlike some of the other issues that are resolved by consensus, meaning they require everyone to agree on the outcome. So I think there certainly is no military carve-out, and and we think that we have built in within the text of the JCPOA the mechanisms to deal with those situations.
Sean Murphy from George Washington University Law School. This was a terrific panel. I'm really delighted that Elle could be here to help us with it, and particularly glad that Mary's here in her last week. My question goes to maybe stepping back from this particular deal and looking at it in the context of a little more of a historical arc. And there's two halves of this. One half is looking backwards and one half is looking forwards. So looking backwards, much of what you've talked about reminded me of the 1990s and the program relating to Iraq, where similarly there's lots of questions about sanctions. Should they be lifted? Should they not be? Compliance with destruction of weapons of mass destruction. And monitoring as well with the IAEA involvement and other weapons inspectors. And I'm wondering how much the lessons learned from that period fed into the process that you just went through, and were some things done differently or the same. So that's the looking backwards bit. The looking forwards bit is I could imagine a similar thing may arise in the future. North Korea comes to mind, but it could be any number of countries. And so the question might be to any of you, what lessons for the future that might be brought to bear on this? And I'll be just a little provocative, and I don't expect you to address this particular point, but the whole idea of the snapback mechanism suggests to me that we now know you can have a creative way of bringing back to life a Security Council resolution. And in the context of the first Gulf War, that war ended with Resolution 687 in a manner that most people thought the use of force component was done. And then the dispute in 2002 to 2003 is, could that use of force component be reawakened, basically? And I wonder if, in light of what we now have with a snapback approach, the arguments would be stronger that you couldn't reawaken an earlier Security Council resolution because you didn't write into it something of that nature.
Thank you, and welcome to law school.
We're back in law school?
Yeah, welcome back.
Should I maybe start and then?
Yeah, sure.
So thanks, Sean, very much for the questions. First, with respect to looking back, yes, looking back to the Iraq experience looking back to the Iraq experience was very illustrative. But other previous Security Council resolutions were too. Actually, looking back at some of the ones from when you said 1990s, I actually thought you were going to talk about some of the resolutions related to the former Yugoslavia, because those resolutions were quite innovative in their own way in allowing for individuals other than individuals who are not members of the Security Council to take actions that would actually trigger UN sanctions consequences. And so both including suspension and termination of sanctions. And so those resolutions were a great source of kind of historical interest and inspiration in considering the possibilities for this set. Iraq was obviously in many ways a different sort of situation than we have now. There are some similarities as well. I think that more generally, there's a very small set of situations where the Security Council has imposed nuclear non-proliferation related sanctions, and then a state, the target state, has reached an agreement with the international community, with all the members of the Security Council, that addresses those concerns, and the Security Council has then agreed to lift the measures that that gave rise, that it imposed to deal with that. Iraq, of course, the sanctions weren't lifted until after 2003, which is was a very different dynamic. So looking forward, I do think it's important and significant that snapback in Resolution 2231 is expressly laid out through a clear procedure, and I think it's that was important to us in ensuring that if a state were to trigger snapback in the future, if a JCPOA participant state were to trigger snapback in the future, that it would be that the procedure would be clear, and the consequences under international law would be clear for all member states. And of course, with Resolution 687, there was a great deal of debate, I guess, and discussion about whether or not the interpretation and the actions taken under that resolution were justified. I think that the fact that Resolution 2231 is so clear really minimizes, perhaps eliminates the chance for those sorts of legal questions to be raised in the event that snapback does occur in the future.
Anybody else on the panel want to say something in response to the question? Well, Mary, do you want to have the final word? Sure. Yeah.
Very brief. I just want to thank you again for coming. I hope this was interesting and educational, and I'm sure the tradition of Live from Mel will continue, or pretty sure anyway. So thank you again.
Thank you again, everyone. Thank you.